Welcome back to the Lost Test channel. My name is Anton Bieltsin and I'm a criminal defense attorney in the Southern District of California. If you've been watching my channel long enough, and from the introduction, you know that I mostly focus on federal and state criminal defense. But if you know me personally, or if you ever go on my website, you will learn that once in a while I do take a civil case. Usually those are bigger cases and I try to select them carefully before I take on a big civil case. The one that put me on the map a few years ago was a case where a foreign bank came to the state of California and tried to sue my client for $30 million. That was a big case, and you can even Google some news articles dealing about it. Well, enough about my case. In this video, I will focus on another civil case that deals with negligence. So let's go ahead and get to this case. The reason I selected this case is because it's interesting on its facts, and it also became a big story here in California because it deals with an officer and his firearm being stolen. So let's go ahead and discuss the case. The case is James Steinle and Elizabeth Sullivan versus United States, City of San Francisco, and Lopez Sanchez. Now this is a civil case, so you have a private party suing the government and individuals in their capacity. Here's the facts. Mr. Woychowski works for the Bureau of Land Management, BLM. In 2015, he travels from El Centro to San Francisco for a family vacation. He parks his vehicle on the street near the Embarcadero around 9:30 p.m. and the family goes to dinner. He leaves a loaded BLM-issued firearm in his vehicle in a backpack without a trigger lock. Around 11 p.m., somebody smashes the window and steals the backpack with the gun and other personal items. About 4 days later, Mr. Lopez finds the gun wrapped in a t-shirt next to a city bench. He takes the gun, fires it, and the bullet ricochets off the ground. Sadly, it strikes and kills Miss Steinle, who was walking by. So here's the facts of the case. The family sues the City of San Francisco, United States, and Lopez, stating that there is negligence in storing and securing the firearm. Mr. Woychowski failed to properly store and secure the firearm. Now, under California law, in order for you to win on a negligence claim, you have to show that there's a duty of care, there's a breach of that duty, and there's a proximate or legal cause. Now, when we're talking about proximate and legal cause, what we're dealing with is really foreseeability. Is the harm foreseeable from the negligence, from that duty? Or is it too far attenuated? Now, the court doesn't focus on the due care or the breach. They focus simply on the proximate cause. Why? Because in order for the family to win, they have to prove all elements of negligence. And if one of them fails, they lose. Hey, sorry to interrupt, but can you do me a huge favor? Can you click on the button below where it says subscribe? Subscribe to my channel if you haven't already. And next time you're on one of those corporate, boring Zoom meetings, why don't you tell everyone to subscribe to the Lost Test channel? I would greatly appreciate it, and other people might find a benefit from it. But anyways, enough of me joking around. Let's go back to the case. In this case, the court said that the harm, the bullet striking and killing Miss Steinle, is too attenuated from the duty alleged. And here I wrote the don't knows. here's the things that we don't know. We know that Mr. Lopez finds the gun 4 days later. He's not the person who steals the firearm. There's somebody else who smashes the window and steals the firearm. We also don't know how the firearm ends up being wrapped in a t-shirt next to a bench. Did that original person sell it or give it to somebody else? Did he lose it? We don't know how the gun ended up on the street. At least 2 people intervened between the events. That's what the court says. We know that Mr. Lopez was one of them, and somebody who stole the firearm from the backpack from the vehicle. But there could be more people. There were criminal acts over which the gun owner, Mr. Woychowski, had no control. And then it was unforeseeable and unusual. We have a crime and we have the accident. Those 2 items are too attenuated from the duty. And for those reasons, the court says that the harm was simply unforeseeable to Mr. Woychowski when he left his firearm in his backpack without a trigger lock in his vehicle. There's just too many steps in between his action and later the action of Mr. Lopez. I hope you now understand how proximate cause works and how negligence in general works in the state of California. I encourage you to look up this case, and I of course will link it in the description below. Click on the link and read the case in full. It gives other examples where the state of California either found negligence or didn't. For example, there's a case that this case describes, talking about an individual suing Apple for not having technology that would stop your phone from functioning while you're driving. And because they didn't implement this technology, somebody got in the accident and got hurt. Now, this was just one of the examples that the court presents. There were a few others, about a handful. So go ahead and click on the link and read the whole case. I hope you enjoyed this video. I know it was a little bit different. We usually don't discuss civil cases, but it was interesting. I also encourage you to click on the news articles dealing with this case. It's rather interesting. And of course, at the end of the day, it is a sad case because I don't think anyone really wins here because somebody actually got killed. And Mr. Woychowski, I'm sure, was not a person who wanted that to happen. It was simply an accident. Hope you enjoyed this video. Click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. Thanks for watching.